just didn't fit whatever they were looking at automatically. So I honestly don't think any human could look at it. So if you're trying to update upload something to your job, my best suggestion is to restart. In other words, like whatever you need to get a fingerprint file, do that from the beginning. That's why I personally think that I guess that's kind of a common conversation with the maritime, but years ago, the invalid I was thinking that I was thinking of one nationally, but if they have it there, or if it's you're like, you can work from your kitchen, yeah, it sounds like you're just running a policy automation. It's not negatively automated. So it's I really appreciate Scott's ability to think I can call this stuff. That's pretty cool. I know Stellar a lot more than I know these things, but based on what I do know, well, I
Good morning. There we go. Good morning. I'm freezing. I think everyone's off to a slow start for Monday. Good morning.
Good morning.
Trying to mark everyone attended as I'm going through. Did you guys all receive the link through the growth zone when I sent it that way? Or did it go through this morning?
I received both.
Okay,
Yeah, both.
thank you. I know some people are having problems when I send it through growth zone. It doesn't open or they don't receive it. Because it usually ends up in the junk mail. So I have to try and tell everyone to get it to accept to go into your inbox. Good morning, Kathy.
Good morning.
Ah, there he is. I was like, Justin's not on yet. Good morning, Justin. How are you today?
Good morning. Good morning, Miss Melody. How are you?
I'm good, thank you.
How's,
I know we're still waiting on 7 more people. So,
Yeah, we'll give it another couple minutes.
all
How are
right.
things? Where are you at? Where are you located?
We are in Winter Haven,
Okay.
Polk County area.
You're chilly as well.
Yes.
It's a welcome change for like a week, and then let's get back to our heat.
Exactly. Yeah, I'll take it for a little while.
Yeah, give me a week of it, and then I'm good.
Exactly. Yeah, I'm just glad I'm not shoveling snow anymore or all the other
No.
fun stuff. Driving in it.
Not about that life. I don't know how anyone else lives anywhere other than Florida, honestly, or somewhere warm. Doesn't make sense to me.
Everything is making a noise on my computer today. All right. Hold on. I don't know if you guys can hear all the ringing and dinging right now. Sorry.
No, I don't hear anything.
Okay. Someone needs that. The link. No. All right. Roughly 4 more people, but I'm good to start whenever you guys are because you're all on time.
All right, let's do it. I like respect people's time. So
Yeah.
Kathy's got her big cup of coffee, I see, so she's ready.
Ready when you are.
Yeah. Perfect. Okay.
Yeah.
Let me see. Melody, so I'll go ahead and I'll start the recording, then we'll get going. And like I said, I'll share it with you, after this, and if
Okay.
someone shows up later or anything. I guess you have to let people in, or can they let themselves in
Yep.
automatically?
No, I'll go
Okay.
ahead and let them in as they come on. I also have it recording on my side. I can shut it
Oh.
off if you just.
Yeah, that's fine if you want, and then I'll record on mine. That's fine.
Okay. All right. Perfect.
All right.
And then I will
So-
send you all the information at the end and vice versa.
Perfect. Okay. All right. Let me get this going and we'll get started.
Okay.
I think you have to give me permission.
Oh, yeah, sorry.
That's all right.
Where are you? More. Make host. Oh, well, if I make you host. There you go.
All right. I think we're going. So, good morning, everyone. Thank you all for showing up. My name is Justin Stivers. I am the owner of the Probate law firm. Main office is in Miami, though we operate throughout the entire state of Florida. So very familiar, Polk County, Winter Haven, that area where I know a lot of you all are. And so, name of this course is called Probate 101 for Realtors. It's a very introductory course. We're going to kind of go over three things. What is probate, right? So when is it necessary, right? So you all as realtors, I can tell you at some point in your career, you will most likely come across a probate from a buyer's perspective or from a seller's perspective, or possibly just on a personal level, you might come across probate if you have not already. So this course is to help you identify when probate even be necessary. Again, Florida, aging population, a lot of retirees down here. Chances are you'll come across it. So that's number one. Number two is we're going to talk about how the probate process works. How long does it take? What you can tell your prospective clients. They're going to be anxious. They're going to want to know, how long is it going to take? What do I need to do? All that sort of stuff. So I'll kind of give you all the basics, obviously, and I'm sure your broker will echo this. If you're not an attorney, don't give anything close to legal advice, but I can give you some things just so that you have a general idea of what's involved in the probate process. And then we'll end with just a couple marketing tips, how to find probate listings, because probably at the end of the day, it's all about getting listings. So we'll talk a little bit about that. Probably going to be about 40 minutes, more or less. We'll save a couple minutes at the end for questions. If you all have questions, just put them in the chat box as I'm going along, and I'll try to answer them. If it makes sense at the time that I'm speaking about something. If not, we'll circle back at the end if I haven't touched on it. And I'm just going to put my contact info in the chat box as well, so that you have that. But then after the call, I'll send you all links to the recording and some additional information as well. So anyways, that's kind of the idea of the course. So I started doing this course about probably 3 or 4 years ago now, because again, just I noticed a lot of people are coming, finding probate listings and aren't really sure, what to do. So first thing first, what is probate? Right? Might be a term that you've heard. Probate occurs after somebody has passed away. So in order for there to be what's called probate, unfortunately, there has to have been a death. And really, for your all's purposes, what it means is taking a piece of real estate that was owned by somebody and now transferring it to their new owners, to whoever the owners are, right? So most commonly, husband and wife own a piece of property. Husband dies, because unfortunately the guys, we always go first. Now the wife owns the property. Okay, so when the wife passes away, who owns that property? If it goes to the kids, most likely they're going to have to do what's called a probate process, do a probate in order to be able to sell it. We'll talk a little bit more about that. So when you hear the term probate, all we're talking about is transferring assets from a person who's passed away to whoever the new owners are. A couple other key terms we're going to talk about. Probably the most important one is what we call the personal representative. Okay, some states use the term executor. You might hear the term administrator, testator, something along those lines. In Florida, we use the word personal representative. I'm just going to shorten it and call them a PR. Just makes it a little bit easier. But the PR is the person who hires the realtor, hires the attorney, signs the listing agreement, signs the as-is contract, and is really the person who's kind of running the show as far as the probate is concerned. So as we go through this, you'll hear me say, time and time again, you assuming you want to work with the seller, want to make sure that you're working with the PR, because they're the ones who are really going to be in control of selling the property. Last will and testament, or a will, you all are probably familiar with that, but just generally what a will is it's a person's wishes, what they want to happen with their stuff after they pass away, right? And so we'll talk a little bit more about a will. And then estate, so ESTATE, an estate. That's what we refer to as everybody's stuff, a person's stuff after they've passed away. So John, while he's alive, John has his car, John has his house, John has his money. But now when John dies, now we refer to John's car, John's money, John's house as John's estate. And so that's what when you all are signing things, we'll talk a little bit more about the listing agreement and everything like that, but you're going to refer to it not as John, but the estate of John. All right, so you'll hear that word a little bit. So those are the main things main definitions for you all to know. So first things first, how are you going to know when a probate is necessary? Now, one of the most easiest ways is you get a phone call, someone says, hey, Susan, my mom passed away. I want to sell her property, right? So you know that somebody has passed away. Chances are it's going to have to go through probate. Now we're going to talk about some ways to avoid probate, but if you hear that an owner of the property has passed away, that's probably going to be a signal that probate's likely going to be necessary. So what are you going to do? Well, when you get a listing, or when someone calls you about a potential listing or a property, if you're working with a buyer, one of the first things that you all are probably going to do is go to the county tax roll, look up and see who the owner is. You might go to the property appraiser's website. That's, in my experience, one of the first things that most realtors are going to do is they're going to look and see who actually owned the property, who's actually on title. And so no different here. So I'm going to share my screen again for those of you who are maybe just on your phone. Like I said, we'll share this after so that you can see it, but I'm just going to show you 3 examples to help you identify when probate might be necessary. So, okay. All right, this first example is a property. So I'm highlighting here where it shows owner. Under owner, it says Maria Pichardo, and then after that, the initials EST of. Probably guess, the EST stands for estate. So when you see this, if you thumbs up if you can see my screen, just to make sure you guys can see it. Okay, perfect. So whenever you're looking at a property appraiser, a tax roll or something like that, and you see this EST of, that means probate's necessary before this property can be sold. 99.9% of the time, if you see this, you would not be able to sell this property until the probate process has been done. So a couple of questions I always get asked. When does the county update the record? When did they put on there the EST of? And the truth is, I don't know the answer. I've seen properties that are owned by someone who passed away, no joke, 20, 30, 40 years ago. Okay, and it still shows them as the owner without the EST of. And I had a client call me last week and their mom had just passed away 2 days before, and the county had already updated to EST of. So I can't tell you 100% when they will update this. I just can tell you that for sure, if you see the EST of, that's going to be a signal that probate, might be necessary. So when you see that, this is probably going to be the most common thing that you'll see. Now, probate might have been started. This is not to say that probate might have already been started, so there might already be a court case. But more often than not, there probably has not been one. So this is, again, probably the most common one that you all will see. And so just look for that. Look for that EST, estate of. Okay, second example. All right, so again, under the owner box, we've got Jesus Silva, EST of, and Maida Silva. Now, we just went over what that EST of stands for. So again, if you see that, we know probate's necessary. But this one's a little bit different, right? This one's a little bit different because we have two people on title. There's two people. What kind of facts behind this one is this was a property that was owned by father and daughter. Okay, they owned the property. They owned it 50-50. And we're going to talk about different types of ownership, but this is what they own this by what's called tenants in common, meaning that Jesus owned 50% of it and Maida owned 50% of it. When Jesus died, he was not married, did not have any other children. And so Maida thought that she automatically owned this property. She goes to sell it, goes under contract, gets to closing. Closing agent says, hey, did you do a probate for Jesus? No, she didn't. She's angry. She's mad at the realtor. No one knew they didn't know that it needed to happen. And now they have to go back and do the probate process, which takes several months. Okay. Very quick search. Or if Maida, assumedly, she would have known that her father had passed away. I don't know if that information was given to the realtor, but if the realtor had said, hey, I see Jesus, is he still alive or what's going on with him? Had she told him that Jesus had died, that might have, hopefully started a conversation about, well, we might have to do probate. So the way they own this property was by what's called tenants in common, which I said, which basically means when Jesus died, his 50% did not automatically go to Maida. Okay, it was owned by his estate, and Maida similarly, she only owned 50%. So a probate was necessary in order to get Jesus's 50% over to Maida. Now, they could have owned it a couple different ways, and that would have avoided the probate process. John, I see your hand raised. Let me get through this, and then if you've got a question, put it in the chat, and then I'll answer it in the chat here in just a second. If they had owned it by what's called tenants in common, or excuse me, joint tenants with right of survivorship, right? Joint tenants with right of survivorship. If they had owned it as joint tenants with right of survivorship, that would have avoided probate. What that means is when Jesus died, his 50% would have automatically gone. Let me see if I can mute everybody. I'm not sure if I can.
Good. You're good. All fine.
Give me just 1 second. See if I can see who we need to unmute here. Okay. All right, so if it was owned by joint tenants with right of survivorship, okay, that means when Jesus died, his 50% would have gone automatically to Maida, and there would have been no need for probate, right? That's a very simple way to avoid probate, is by putting that language on there. So that's one way that it could have been avoided. Another way that it could have been avoided is if they had done another type of deed, which is called a life estate deed or an enhanced life estate deed. Some people call them a ladybird deed. And basically what that means is I own the property, but when I die, I want the property to go to, let's say, my brother, right? And so my brother's on title with me. I'm the sole owner. When I pass away, my brother now becomes the owner of the property and no probate is necessary. That's another way that you can own the property without avoiding avoiding probate, is by doing a life estate deed. A will, so a lot of people get confused about this. A will by itself does not avoid probate. And so we get this issue all the time. If someone goes and does a will and you say, hey, listen, I want my kids to get the property when I die. you pass away, and now your kids, they've got a copy of your will, and you go to the county and you say, look, my dad did a will, he says I get the property. The clerk is going to say, unfortunately, you need to hire an attorney and you need to go through probate in order to put the property into your name. And so I get that call almost every single week where someone didn't know that. Maybe the parents didn't know that. They did a do-it-yourself will or something like that, and now they didn't know that their kids are going to have to go through probate. We get that all the time. So a will is not going to avoid probate. The easiest way is by doing, changing the type of deed and changing the actual title. Another way, though, is by putting the property into a trust. Okay, and so a trust is very similar to a will in the sense that it says what happens to a property or assets after you pass away. But the difference is if you do a trust and you do it correctly, it will avoid probate. And so here's an example here that was done properly. So at one point, Miss Rodman owned the property in her name only. She bought the property, it was in her name only. Her attorney created a trust document. Again, very similar to a will, a piece of paper, a lot of pieces of paper that says what happens with a person's stuff. Then she did a quick claim deed. She did a new deed, and she actually transferred the property from her name individually into the trust. So the owner of the property is no longer Karen S. Rodman. It's the Karen S. Rodman Trust, and that's what TRS stands for. In this case, she has a daughter who is the beneficiary, which is this BEN. So what happens is when Karen passes away, her daughter, Karen, is not going to have to go through probate because her name is basically already on title. The trust already owns the property. And so probate is now avoided. And so this is another great way. To avoid probate. A lot of people get confused about trusts and they think, oh, it's only for, people with billions of dollars. All I have is my house. I don't need to do a trust. Well, if one of your goals is to avoid probate, then a trust is probably a better option than changing title, right? Because remember in the previous example, I talked about joint tenants with right of survivorship. Well, maybe you've got two kids, okay? And you want to leave the property to your two kids, right? 50-50, equal, make it easy for them. I'll stop sharing my screen here. And you want to make it, easy for them, just 50-50. Okay, so you put them on the title as joint tenants with right of survivorship, or as the life estate tenant. So you pass away and now the property goes to them. No problem there. But what happens if the two kids can't agree on what to do with the property? Now they're equal owners. Now they own the property 50-50. Maybe one of them, wants to live in it. The other one wants to sell it. Or maybe, who's going to keep paying the property taxes? Maybe they're in a different situation financially and they both can't afford, one can afford and the other can't. So now it's unfair. Well, what you might want to do or consider is you put the property into a trust, and the trust is going to say, I want to leave the property 50-50 to my kids, but if they can't agree what to do with it within 90 days, I'm instructing that the property be sold and that the property and the proceeds be split 50-50. That's just an idea. That's something you can do in the trust, which you can't do if all you do is change title. So that's another one of that's another benefit about putting the property into the trust. So that first little section is just to kind of show you when probate might be necessary. Again, if you see that EST, that's probably going to be, a giveaway that probate's necessary. When you see two people on title, don't assume that the person who is still alive automatically inherited the other person's portion of it. They might not have. You got to look at title to see what title says. And then if you see that it was in a trust and it was done properly, that's probably going to avoid probate. But remember, having just a will is not going to avoid probate. And then one other thing on that is husband and wife. If you're married and you're both on title, you're probably not going to have to do probate. But what you want to look at is, this is where I see a lot of times with older deeds where, people maybe got married and they bought the property in the 70s or the 80s. A lot of times the title might just say, it's probably going to have the husband's name. It might just say John Smith, a married man, but it doesn't list the spouse's name. And if it doesn't have the spouse's name, when the husband dies, the surviving spouse is probably going to have to do a probate to put the property into her name. Or if you bought a piece of property before you got married, and then you get married and you never change the title and the property is only in that person's name, when that person dies, probate's going to be necessary. So I always encourage clients, hey, look at the title, especially if it was, a while ago, look and see how you all own title. If both husband and wife are on there, both names are on there, probate's not going to be necessary. So if it says, my wife's name's Alexandra, our property says Justin and Alexandra, a married couple. I die, she doesn't have to do probate because she automatically got the property and vice versa. But if it just had my name and not her name, she'd have to do probate. So I'll pause right there, see if anyone's got any questions. And I see a couple in the chat. I'll answer in a second. We answered if it's in a trust, not going to avoid probate. Will it say joint or other online? I'm not really sure what that means. If it's joint tenants with right of survivorship, there will likely be a designation on the property website. It's going to say JTWROS, joint tenants with right of survivorship, or trust, TRS, something on there. But, I'm sure you all have witnessed this or experienced this. The county clerk is not perfect. So there might be errors on the actual property appraiser website. What you want to look at is the deed. That's going to be the main thing that's going to tell you who actually owns the property. Does a property left to the children, does the title have to be changed in the kid's name, then changed again when they sell it? I think so. If you leave the property to children, it depends on their age. If they're under age of 18, you can't really put them on title just by themselves. So I'm not sure I 100% understand the question, but when you sell that, when a new party becomes owner of the property, yes, you want to have the new owners on the title. And then what other assets should be put into the trust? Really depends. Most commonly are going to be is money, bank accounts, retirement accounts, 401ks, possibly even life insurance policies. Trust is a whole nother thing I do presentations on. Happy to do one on that if there's interest in that. But yeah, if you want money to be distributed, or you want things to be distributed, to your kids in a certain way, most commonly we get a lot of clients who say, listen, I'm not crazy about my son's wife, or I'm not crazy about, my daughter-in-law, whatever. I don't want to leave him this money, and then they get divorced and now he or she takes half of it. So if you just leave the money outright to them, and that, you leave whatever amount, $500,000, $100,000, $50,000, whatever it is, and you leave that money to your kid, and that money goes into his bank account, and it's a joint bank account with his spouse. If they get divorced, he or she's taking 50% of that. No questions asked. If you are concerned about that, you can put that money into a trust for your kids. And so if they get divorced, that's not going to be touched if done properly. So there's a whole lot of things you can do if you're concerned about that. Again, I'm a little, straying off a little bit of the topic here on probate, but definitely, something you can talk about with your clients as well, and kind of an added value, which they might not even be thinking about. They might not be thinking about, hey, how should we own this property? So that's something you guys can talk with them, or if you have more questions or interested for yourself, give us a call. Happy to talk with you all about that. So, okay, part two. So now you've kind of determined that probate is necessary. You've looked at title, your attorney, your underwriter. It's been confirmed probate's necessary. So what's the process look like? All right. You go to meet with them. All right. I always remember I said in the very beginning, you want to make sure that you're working with the PR, with the personal representative, because they're the ones who's going to pick the realtor. So you kind of need to make sure you're speaking with the right person, right? So I suggest asking two questions. Number one, ask the person that you're speaking with if the person who died had a will. And the reason you're going to ask this is because let's say you're speaking with the brother. Okay. And the brother's like, oh yeah, my parents love me. They're leaving me the property. I know that. Only to find out there was a will, and parents didn't really like the son. Okay. And they're like, no, son's not getting anything. We're leaving it to the daughter. But you've been spending all this time speaking with the son. Well, if he is not going to get the property and the will names the daughter as the PR, chances are you're not going to get that listing because the daughter is going to talk with somebody else. She hates her brother, doesn't want to speak with you because she knows you're in cahoots with him, right? So first question, ask them if they had a will, right? If they did have a will, or if they say there was a will, ask them if there's a copy of it or if they have a copy of it. And the reason is, again, I get this call pretty frequently. Hey, Justin, my mom just died. She had a will. I just don't know where it is. Can you get it for me? No. For the most part, wills are not recorded, right? So there's a lot of online services, and even for attorneys, we could do a will right now, do it on a piece of paper. I put it in my desk. If nobody knows that will is there, nobody's going to know about it. So if you do a will, or if your parents do a will and they don't tell you where it is and they pass away, I'm not going to be able to find it for you, right? That might be in one of their safe deposit boxes that you don't even know they have a safe deposit box. So we're never going to find it. Or they left it with their attorney who drafted it 30 years ago, who died, and now no one knows where it doesn't have an office anymore, right? So that's why you want to ask them if they have a copy of it, right? Because if they just tell you, my mom had a will, but I can't find it, chances are we're not going to be able to find it either. So ask that. And then the second question is, ask them what the relationship is to the person who passed away. Was this your mom? Was this your brother? Was this your, third cousin twice removed? Who was this? And the reason is, in Florida, if there is no will, there's a hierarchy of who gets what. So first it's going to be the spouse, then it's the children, then it's the parents, the grandparents, the siblings, on and on until you get, again, to second, third, fourth, whatever cousins. And so if you're speaking with somebody and they say, I'm the cousin, but she was like my mother, she raised me, whatever it is. But if she had other kids, those kids are going to be entitled to whatever they have, even if they were terrible kids, hadn't talked to their mom in 40 years, were drug addicts, stole from her, whatever the case may be. And I hear it all. If they are closest in relationship to that person, they're going to be the beneficiaries, and they're going to be the people who have the rights to hire the realtor, sell the property, do all that sort of stuff. So find out what the relationship was to them. Any questions on that? I don't see anything coming through, but pause right there if y'all have any questions on that. Okay, so now let's say now at this point we've determined that that you are speaking with a personal representative. This is the person who is going to hire the probate attorney, go through the probate if they haven't hired one yet already, go through the process. So what do you need from them, right? So you're going to need obviously a listing agreement, right? That's step number one. You need them to hire you. The way they'll sign it is once they are named as the personal representative. Let's just say Sarah is named as the personal representative. Well, in a normal listing agreement, Sarah's going to sign it. I, Sarah, hire you, Johnny, to be my realtor. But this property is not Sarah's. It was Sarah's mom's. So she's selling the property on behalf of the estate. So the listing agreement needs to say Sarah as the personal representative of, Susan or, Sherry, whoever passed away, right? So it needs to, so it's going to have Sarah's name as the personal representative, because she's selling the property not as herself individually, but she's selling it as the personal representative. So that's a big distinction there. Then once you get to the sale, once you get to the as-is contract, you found a buyer and everything, same thing. Sarah's not selling the property individually. Sarah's selling the property as the personal representative. So when she signs the as-is contract, she's signing it as Sarah as the personal representative. That's pretty much the only, one of the only, or the main difference for you all when you're working with probate listings or purchasing a property, is that the seller is usually going to be the estate. It's usually going to be the personal representative. Now, and I forget which paragraph it is, but in your as-is contract, you might need some language that says subject to probate court approval, right? And that just one sentence, subject if you need court approval for the sale, which I can talk about here in a second. But other than that, for the most part, that's really the only thing that's going to be different from your all's point of view. Now, probably first question you all are going to be wondering, and first question the client's going to be wondering is, okay, how long is this going to take? I've heard nightmare stories. How long is this going to take? There's two situations, right? So two scenarios. It really depends on when the person died and when the probate is started. So if the person died more than 2 years ago, right? So right now we're at the tail end of 2021. If the person died in 2015, so obviously more than 2 years ago, it's going to take about a month to get the person named as the PR. And then we're going to ask the court to transfer the property to the new owners or have the sale approved. So on average, I say it's about a 3-month process if the person died more than 2 years ago. Okay, so that's the first situation. But probably most of your clients or the people you're working with have passed away more recently. So within 2 years. So we're in 2021 and they passed within 2021 or 2020. Okay. If that's the case, still going to take 30 days to get the PR named. So that's month 1. And then there's a rule, a Florida rule that says you cannot transfer any real estate or sell any real estate for 90 days after the personal representative has been appointed. Okay. And the reason is we have to give notice to any creditors that the person might have had. So the person died, he or she owned his house, but they owed money to Visa, the hospital, unpaid hospital bills, unpaid debts, something like that. We have to wait 90 days in order for that 90-day period to expire before we can ask to transfer the property to the new owners or to get the sale approved. So in this example, when the person died more recently, we waited 30 days to get the PR named. Now we got to wait another 3 months for that 90-day creditor period to expire. And now we're in month 5. Now we're going to ask the court to sell the property. So in this situation, it's probably going to be about a 5 to maybe 6 month process. All right. And that depends on the complexity, right? Depending on, so many different factors, it can depend. But in a perfect world where it's just very simple, no issues, siblings aren't fighting, the judges, are signing stuff quickly, 6 months is probably a pretty fair situation. Now, when it comes to the creditors, just so that you all know, the clients are not personally responsible for those debts. So when mom, dad passes away, you as the kid are not responsible for those debts. The only thing that the creditors can go after are any assets of the estate. If the only asset of the estate is a person's homestead property, which you all are probably familiar with homestead, but in case you're not, homestead is in Florida, it's protected from creditors. It's your primary residence. You live there the majority of the year. You get a tax benefit on your property taxes. If all you have is a homestead property, you could have $1 million in debts. They can't touch the homestead property. So you'll be able to sell it. The kids get their money, you get your commission, and those creditors don't get anything. That's why, I think O.J. Simpson, when he was going through all his stuff, bought a huge house here. And a lot of people move here, they buy, houses that have debts because they know they can't be touched. The only ones who can really go after them, the IRS, unpaid property taxes, the county could foreclose for unpaid property taxes. HOA dues, HOAs, as you all probably know, are extremely aggressive. So if you owe them $1, they'll foreclose on you tomorrow. Or lenders, if you owe, obviously money on a mortgage, that's got to get paid. Apart from that, if it's your homestead property, probably not going to be touched. If it's a secondary property, right? So if it's a investment property, creditors could go after that. So that is fair game. If it's a secondary home, it's not your homestead property, it's an investment property, a rental, a vacation home, they could potentially try to go after that money. Now, your fees, my fees, and realtor commission, that's protected. We're good. but the proceeds could possibly get eaten up by those creditors. So that's something to pay attention to. But most of the time, you're probably going to be dealing with a person's homestead property and are not going to have to worry about creditors all that much. Okay, anything else? So, so there's something called, someone asked, there's something about summary administration of probate. Really doesn't change the process all that much. It's really not going to change the length of time all that much, regardless of, there's a lot of misinformation and material out there. Just by way of experience, we do about 400 probates every year throughout all 67 counties in Florida. And again, the averages are pretty accurate. It's about 3 months or 6 months, depending on when the person passed away. And then someone asked about auto loans. Same thing, that's just a normal creditor. They're not gonna, for auto loans, there are remedies to go after the car, right? They, the collateral that you signed up is the car, so they might repossess the car. That's really what they're going to go after for the most part. Okay, so and then just a couple thoughts on marketing for probate properties. Part 3 of this. I've seen a couple different things work. All right, so I've had realtors swear by buying lists. So you can, probates are public record, which is again why a lot of people don't like probate, and they do a trust or something because they don't want all their information public. Excuse me. So you can buy lists and you can get the information. Excuse me. You can get the information of who the personal representative is, their contact information. You can get the information of the attorney who's representing the personal representative, and you can call, email, direct mail, and try to go about it that way. And I've had people have success with that, right? So that's one option. The other option is, again, it's public record. I've had people who will find these lists and they'll do direct mail, door knocking, that sort of thing, and have success that way, or just networking with other probate attorneys. Again, most if you in your area you have attorneys that do a lot of probate, work with them, reach out to them and say, hey, listen, I can help you with this. Now, the one thing I mentioned about probate, which is a little bit different than your typical sale, is remember, someone's died. This might be a person's childhood home. Mom just died, very emotional time. They've got siblings that are fighting. So coming at them aggressively saying, hey, I can get this sold for you cash 30 days or whatever, might not be the best strategy. You might want to have a little bit more empathy when you're trying to go after these types of properties. In my opinion, I forget the stat, but it's a lot of realtors in Florida, right? I'm sure there's a lot of realtors in your area, a lot of competition. If you do find a property and you see that it's owned by, or it has to go through probate, just bringing up that information to the prospect is going to set you up and differentiate yourself from a lot of your other competition. Because like I said, I work with a lot of realtors. Most realtors have no clue what probate is, I get so many phone calls of people just saying, hey, do I need probate for this, or is this? And if you study this and can kind of hold yourself out as an expert once you are an expert on this, it's a great differentiator. I know a realtor in the South Florida market who she's done a phenomenal job as just being like the go-to. Like if you need to sell a property in probate, she's your person. Now, just because she's branded herself that way, right? And so I think there's a huge market for that, especially for out of state people, right? For example, a lot of my clients are out of state people. Kids live in New York, but the parents moved to Boca. They passed away in Boca. The kids live in New York. They don't have any connections, in Florida. They don't know anybody. So then I get to kind of be the quarterback to say, hey, work with this person, work with this person. And if they're, where are they going to find us? Google. And if the thing that comes up is top probate realtor Boca Raton, which probably not a lot of people marketing themselves that way, that's a good way to differentiate yourself. So those are just some ideas. You can also, and one last idea that I've seen work is you can go to the the property appraiser website, if you just type in, for most counties, this doesn't work for all counties, for a lot of counties, if you just put a state of and you search by a state of, you're going to get a whole list of properties that are owned by estates. Probate might not even be open for those ones. And so now that gives you a list that you could potentially try to, again, direct mail, door knock, something like that as an idea. So that's kind of what I had here. I got, if you have any other questions, let me see if I can answer them. I'll throw them into the chat or try to answer real quick. So if the deceased heir doesn't want to sell the probate home, they just want to transfer their name in their name, they'll only need a probate lawyer and no need for a real estate agent, correct? Yeah, if they don't want to sell the property, they're not going to need an agent. If they're just wanting to put the property into their name, which happens, sometimes people don't want to sell the home. So if they're not selling, they're probably not going to need a realtor. And I know of a house that is in probate. Is there a way online I can find out who the PR and the attorney are? Yeah. So again, most counties, all counties, probate is going to be public record. So what you would do is you'd want to search by the last name in the clerk of court records and try to find it might take a little bit of digging, but it would be public record. The PR and the attorney information is public record. So yeah, and I put my contact in there, my email, justin@probatefirm.com. The name of the firm is the Probate Law Firm. You'll find us on, all social media channels. Our website is probatefirm.com, keeping it simple. So happy to, help in any way that I can. Melody, thank you so much for inviting me or having me. And unless you all have anything else. Yeah. Thank you all. Appreciate it. Have a great day.
Thank you.
All right.
Take care.
Thank
Bye.
you.
Thank you to the same.
Thank you all.